Alright, so we got some action on the auto key card case. Kind of. Once I explain, you'll understand what I mean and why I put the kind of in there. But it's a good thing. And I've been getting a lot of questions about the auto key card case anyway, so it's time to make a video and just let everybody know where we're at. But first, don't forget, I am permanently demonetized from YouTube, so I use the sales at my store, OnlyTacticalFans at Shopify.com, to pay for all this and pay for all my bills. Shouldn't be this way, but after the government coming after me and NSNBC doubling down and doing a hit piece article on me, well, that's the way it is. So I have to push merch in my videos. I apologize for that, but you can purchase some cool stuff there, like these awesome t-shirts, morale patches, survival gear, stuff like that. Stuff you probably didn't even know you need until you found out you needed it. So definitely go check out the store because there could be something there you actually need. Anyways, moving on. So what are we looking at here? So we are at 147 days since verbal arguments. That's 4 months and 25 days. Now I'll explain why I didn't shoot this video at exactly 4 months later, but we'll get there. Alright, so the average case, this is them, there's just some sort of dissent in there. One of the judges don't agree with them. They're figuring all that out. Drops between 3.5 and 4 months. So we're past that. We're pretty much at the 5-month mark, which puts us into cases that set law, where they set the law for the 11th Circuit, and we're just about there. Once we hit the 6-month mark, they're probably going to drop a decision that is literally going to change the law for the 11th Circuit. Now, conviction affirms, they typically happen in 30 days. We're so far past that. The odds of getting a conviction affirmed at this point is pretty low. We're looking at either just there was dissent and they're ultimately going to come out with a decision. It's going to be a published decision and they need to deal with the dissent with the judges, and that's why it's taking a little bit longer, and we're at that happens at the 3.5 to 4 month mark, or they're going to go against the government and set new case law, and that's at the 6 to 9 month mark. So we're just about at the 6 to 9 month mark. So what are the reasons that it is taking longer than just 30 days, even if they did want to just affirm the conviction? Serious deliberation. In my case, we brought up major First Amendment and Second Amendment issues. Remember, the government said that, we're going to pretend this is the auto key card, even if this etching was just drawn on with a Sharpie, they still would have pursued it. So it's not the material, or how to say it. What they're trying to do is regulate the image itself, because it doesn't matter whether or not it was etched on, they would have still pursued it even if it was put on that piece of material with a Sharpie. So that means that if you draw with a Sharpie a lightning link on a piece of metal, that puts you in the same category I just went to prison for. So that's a huge First Amendment issue. Is the government allowed to regulate drawings? Because we're not talking about the etched in the metal, not an almost part, strictly the drawing itself is what they decided made it illegal. Then we had the Second Amendment issues. Because remember, at trial, Bruin was supposed to be applied. The trial judge should have been like, hey, in order for this case to move forward, the government needs to prove that there's text, history, and tradition why the auto key card is regulated. Instead of that happening, the judge was like, no, we're not going to apply Bruin because the auto key card is dangerous and unusual, so therefore, we're just going to kick that down the road. So should they want to affirm the conviction, now they need to apply Bruin to it and be like, all right, so this is the text, history, and tradition and why the auto key card is regulated. So we got First Amendment, Second Amendment issues. That's a huge deal. So even if they want to affirm the conviction, it's still going to take 3.5 to 4 months because they're going to have to deliberate about that. Obviously, they're going to put out a published opinion, because otherwise it would have been just done in 30 days. It would have just been conviction affirmed. So there's something in there, something that gave them pause where they're arguing about it or debating about it. Either way, they're going to put out something. So that's actually pretty cool. Writing for history. If they're going to go against the government and be like, hey, no, you guys don't get to regulate drawings, or no, this is covered by the First Amendment, what they write is going to be recited by lawyers and other judges for decades. So they have to make sure it is airtight. Every single word matters. That's why it takes them 3.5 to 4 months to do a published opinion, because they're writing for history. So that takes a lot of time. They're going through that. It's another good indication that, hey, I'm going to get some sort of victory, because why write for history if they're just going to affirm the conviction? If they're like, all right, so the lower court was right, the government can regulate drawings, no the first, and the Second Amendment doesn't apply, conviction affirmed, it'd be super simple. Look at Tate's case. They basically just rubber stamp affirmed. Happens within 30 days. So we're past that point. Dissenting opinion. One of the three judges could have an opinion that's different than the other two, or maybe they agree but in a different way, like they want to write something about the law. So with dissenting opinion, what's happening is the judge will put out the opinion and they'll send it to the other two judges. Those judges will have to respond to that or answer to that, and then that comes back to him, and then he says something, and then it goes out to the other two judges, or all three of them can be sending dissenting opinions. Either way, again, that's another good sign because we gave them pause. They can't just rubber stamp this one as conviction affirmed. So that's pretty awesome. Now, these are all options of why there could be the delay. We're just going through all of them. The next one is holiday delay. Because this happened in September, well, you got Thanksgiving, you got New Year's Eve, you got Christmas. The holiday delay, when you have a case around that time period, will typically push you back 3 to 4 weeks. And that's, again, why I didn't drop this video at the 4-month mark. But now we're at 4 months, 25 days, so we're basically absorbed the holiday delay. So even with the holiday delay, we've just hit the 4-month mark, so we're just going into where they're probably going to set a new law. Published opinion, like I said in these two. It's almost guaranteed they're putting out a published opinion, otherwise if it would have been conviction affirmed, we would have heard in 30 days. So there is some sort of published opinion likely going to drop, whether that is pro or against. But again, the longer we wait, the farther and farther they drag this out, the more likely it is they're going to be ruling in my favor. All right, so if they're doing a published opinion, well, what's going to have to happen right now is the clerk of courts is going to have to go through the NFA, piece by piece, line by line, all the history, all the other case laws that happened before this. Is there any incidents anywhere where the NFA has regulated almost parts, potential parts, drawing of parts, precursors to a parts, is anywhere at all? If they can find that, that's what they're going to likely build it off of. Otherwise, they're going to wind up trying to build it off of like cargo, because that was the whole case about the 80%ers, because that's not a firearm. But the Supreme Court was like, well, it's close enough to a firearm. So they're going to try to find out a way to shove the auto key card into the cargo case. Again, that's if they rule against me. Either way, that's going to take a lot of time. So that is an option where they're going to rule against me, but it's still going to push me up to the 3.5 to 4 month window. But it's likely if they were just going to affirm the conviction, again, I would have heard in 30 days. So I'm probably going to get some sort of victory here. But again, they're going to have to go through the NFA piece by piece to make sure that they're not wrong. If they're going to rule against the government, it needs to be airtight, because 100% the government's going to appeal. Now, there's the option that they don't, but it's not very likely. Chances are, if they rule against the government, especially where I sat all my time because I will be coming at them with a lawsuit, the government's going to appeal. So they need to go through and make sure that they're not wrong. They have to find some sort of evidence where the NFA clearly says we regulate almost parts, or drawing of parts, potential parts, maybe becoming parts. Or if you want to go the First Amendment route, if somebody declares something, if I say, I want to scratch my full auto itch and this is a machine gun, does the NFA regulate that? And it absolutely doesn't. We've already been through the NFA a billion times. We all know it front to back. The NFA absolutely does not. It only regulates machine gun conversion devices, or a combination of parts designed and intended to convert a firearm to a machine gun. A drawing of parts is not a combination of parts. Anyways, we've already been over that a bunch, so I'm just going to keep moving on. So, this strongly suggests some sort of win. Whether that's a small win, like a mistrial, or finding me innocent but without prejudice, because there's different types of wins, right? You got a mistrial, the government has the option to try me again. This is complex, because that's not an instant victory. Now I have to find out, is the government going to try me? And if they're not, then I have to try to figure all this out, and it's just a whole headache. So we're hoping for some sort of win, but there's winning with and without prejudice. With prejudice, I believe, yes, with prejudice, they can't go after me again. Without prejudice, they could go back and be like, well, yeah, so we can't get him on machine guns, but we're going to go after him for some sort of tax law or something like that. Now, this is my understanding of it. I could be wrong on this. They might have to go after me still for the auto key card, but I think when I win with prejudice, they can't touch me, period. without prejudice, they can find another way to try to shove this through trial. The judges are basically like, hey, there was a crime committed here, but this was not it. Try again. So we'll have to see how all that goes. Now, where I already set the time in that, would they go after me with a mistrial? It's possible. I mean, we have an autistic prosecutor that is hell-bent on sticking this with me. I have no idea why, but she is. And the ATF that is hell-bent on sticking this with me, so they may. They very well may, but it's not likely. Chances are, if I get anything but conviction affirmed, I'll walk. We'll have to see though how it plays out. What is the time frame for that? I have no idea. So, what's all this saying? Like, in the end, some sort of presidential opinion is going to be set. Whether that's pro or against me, it's hard to say. Chances are, though, if it was against me, it would have already dropped because they would have just affirmed what the lower court had already done. So chances are, it's a positive presidential opinion. Now, that doesn't guarantee anything. That's just looking at where we're at, the average cases, how long they typically go through, and what this says. I'm moving into, right now I'm basically at the 5-month mark. Not quite there. 5 more days I'll be at the 5-month mark. That's 1 month short of where the average is, where they're actually setting new case law. Once you get into the 6 to 9 month mark, that's typically where the 11th Circuit, other circuits are different, but the 11th Circuit, they're dropping some sort of new law that's going to rule over the 11th Circuit. So, let's see how it goes. Anyways, I appreciate all your guys' support. I couldn't have done this without you. Thank you. Like, for real, thank you. And if you'd like to help support me directly, but you don't want to shop at Only Tactical Fans at Shopify.com, the other way to do it is go down in the affiliate links, click on that Amazon affiliate link. Even if you don't buy what that link is for, just clicking on it and doing the Amazon shopping you're already going to do anyway, I have a kickback for it because you came there off my channel. Thank you for watching. Don't forget to subscribe.